Hey there, legal warriors. In this video, I'm going to cover 4 mistakes that I see people make when it comes to Department of Licensing matters, Department of Licensing hearings, and figuring out just generally how to deal with the Department of Licensing in Washington State regarding your driver's license. If you're interested in this side of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm has been defending people charged with crimes all throughout Washington State for more than 25 years. I'm putting out these videos to help educate the public. So if you find it useful, please like and please subscribe. More people get to see it. More people get the help they need. Jumping right into it. The Department of Licensing in Washington State, of course, regulates who has a driver's license, when it gets suspended, how it gets reinstated, and takeaway number 1, although not the 4 mistakes, is if you got a question about your particular Department of Licensing issue, you need to go to their website, www.dol.wa.gov. And there's going to be a License Express account type feature where you can log in with your driver's license. If you don't have an account, it's easy to create, and you can get a lot of automatic information about if you have a license, what you need to do to reinstate your license, things like that. And so that's a pretty good website. But what's not good is the other ways that the Department of Licensing communicates with people who get into criminal charges or even traffic ticket type charges that end up suspending their license. They have this modern system, this Licensing Express account, where it's pretty user-friendly, and they've got this terrible, antiquated Flintstones type situation where they send out these really hard to read, hard to understand letters that you may or may not get, who gets their mail anymore, informing you of certain things. And I want to cover 4 mistakes that I see with dealing with the Department of Licensing in this situation. So what's the first big one that I see? Well, it involves DUI cases. If you happen to get accused of a DUI, there's a pretty good chance that there's going to be a civil-based license suspension, a suspension not based upon what happens in criminal court, but based upon what happens regarding a breath test, 0.08 or higher for alcohol, 5 nanograms of marijuana or more for a blood draw, or a refusal of those type of things. And so what happens in that situation is if you have run afoul of the civil licensing stuff, you had a breath test above 0.08 is the most common one, you're going to get sent a notice by Department of Licensing that says, hey, we're going to suspend your license for, if it's a first offense, for 90 days is the most common thing, on a certain date, starting at 12:01 a.m. So if you request a licensing hearing now, then they're going to send you a hearing date in the mail. Now, this is what I've seen happen recently. So let's say you get a DUI on March 1st, 2025, and you get a notice, you're supposed to get a notice in the mail saying, hey, we're going to suspend you on April 1st, 2025. But let's say you're really on top of things and you request a licensing hearing right away. It used to be that the Department of Licensing would be sending out 2 separate notices. They'd send you one saying, hey, we're going to suspend you on April 1st, but then they send you a separate letter that would say, hey, we're going to set you a licensing hearing for a certain date, and any temporary license you have is extended until that date. So if you really look at it closely, you can sort of figure out that means, hey, my license is good until the licensing hearing date. That's already confusing enough as it is. But what I've seen them happen recently is where they're sending out both notices at once, right? Well, we got one sheet that says, hey, we're setting you a hearing for example, April 25th, and the other sheet says, hey, but you're suspended on April 1st. And so then you get this driver who goes, well, I have a hearing April 25th, but I guess I can't drive between April 1st and April 25th. And yet you're still legal to drive, but because they're sending them at the same time, they contradict each other. And even a non-criminal defense attorney would have no clue what that means. And many criminal defense attorneys would have little clue what that means. If you run into a situation where you're confused about your driver's license or your loved one's driver's license, you can actually go to the licensing website I already mentioned, and you can search, check the status of a license. You don't need to have your own License Express account to do this. If you have somebody's driver's license number and their date of birth, it's going to tell you if there's a valid license. So I just had to do this for someone who called my office very recently. This poor guy hadn't been driving for weeks, waiting for a licensing hearing. He's got his buddies taking him to and from work. He can't go anywhere. He wants to be legal. And I've been doing this for 30 years, and I say, well, that's not right. Your license should be valid until this date. So what did I do? I got on the website, I got the license, I looked, he's valid. So this whole time, this poor guy, due to the Department of Licensing having really poor paperwork, he's been sitting at home, not driving, inconveniencing everyone else when he could have been driving all along. So that's one problem that I see, and that's a big one. The second problem that I see is for non-criminal matters. Let's say you get a traffic ticket, and for some reason you fail to respond to the traffic ticket, or you do respond to it and you don't go to the court date. What happens then? Well, now the Department of Licensing is going to send you a notice saying, hey, we're going to suspend you on a certain date because you failed to appear for a hearing. But sometimes those notices aren't specifically telling you, the actual hearing you didn't show up for. Or if there's more than one hearing, they only tell you about you're suspended for one reason and not for the 3 other reasons you missed also. And it's so gobbledygooky that people just shut down and they don't want to deal with it. So if you get any type of notice from the Department of Licensing talking about a suspension, it's time to immediately get on your Department of Licensing License Express account and see what it shows. You can get a copy of your driving record, or you could contact an attorney, a criminal attorney, who will have some idea about what this means and how you can clear it up. If it happens to list a court, because a lot of them aren't nowadays, if it happens to list a court, then you can get a hold of the court and say, what do I need to do to clear this suspension? And you could also ask the court, can you tell, do I have any other holds on my license? And now a clerk may say it's not my job, called Department of Licensing, but the clerks do have access to a certain system that should show them everything, right? Us private attorneys don't get that, but the court does. And so the court oftentimes can help you. So the mistake to avoid is just being overwhelmed by this sort of incomplete information and doing what you need to do to act on it, because if you fail to respond to traffic tickets in Washington State, you will get a suspended license. Then if you drive on the suspended license, it's not a defense that you didn't know about it, right? It's basically, if Department of Licensing can show they sent notice to some address, almost always that suspension is going to stand up, and that's something that really, hurts a lot of people, okay? It really causes a big problem. So what's the third mistake I see with the Department of Licensing paperwork? Well, it's post-conviction stuff. So there's several types of crimes that will suspend your driver's license. The non-felony crimes that suspend your driver's license would be a DUI conviction, a reckless driving conviction, or a hit-and-run attended conviction. That means you're convicted of hit and run with another vehicle where someone was in the other vehicle, and let's hope you don't get convicted of that, because that's a really bad one. That's a 1-year suspension, and most attorneys won't allow that to happen because that's just a really bad suspension. But anyway, what happens in those situations is the court tells the person in court, hey, you realize that the minimum suspension for this is 30 days or 90 days or whatever it is, and then the person walks out of there thinking that their suspension started right then and there. Right? They think, well, the court said I'm suspended for 30 days, I'll stop driving. But that's not how it works. There is mail that gets sent out, and the mail will have a proposed suspension start date. Basically, the court communicates to the Department of Licensing. The Department of Licensing then generates a notice saying, hey, you got a reckless driving in this example. We're going to suspend you for 30 days. And it doesn't start right away. They give you a suspension start date. And why do they have to do that? Because they give you another form in there that gives you a chance to challenge whether it was you or not. So the mistake is many people another mistake is they send in that form thinking it's like a request for a hearing like a DUI, but it's not. It's a chance for you to be able to assert it wasn't me in court. It was my evil brother or my evil sister or my long lost nemesis that was using my name. You can challenge the fact that you're in court, or you can challenge the fact that the record's not right, but it's not about relitigating the thing. So sometimes people stop driving too early, and sometimes people send in these forms that create a bunch of other problems for them, and just sort of, puts a wrench into the works that we need to avoid. So definitely, if we have a conviction of something in court, it's going to trigger more confusing information. You need to talk to your attorney so you can make sure that you're doing it right and not doing it wrong. Because again, the court doesn't tell you, the court doesn't practice law, right? The court is not a defense attorney. They don't know what goes out because they just don't deal with it. It's us people in the trenches that get to see all the nonsense that our clients are supposed to interpret in one way or another. The final mistake that people end up making, again, has to do with notices. And this would be if we have some type of temporary violation that can be cured, right? We have a suspension for 90 days. We're through with that. And now we don't have a driver's license because we haven't cured what I'm going to call a violation, not following the rules of Department of Licensing to get our license back. We have to read that paperwork. So many people think that after suspension is over, we can just go willy-nilly drive. And almost always that's not the case. Almost always we're going to have to at least pay our issue fee. It's a DUI conviction. We're going to have to prove alcohol treatment. There's going to be something called a blue sheet. But, our suspension is up. It said we're suspended for 90 days. We're suspended from April 1st to May, June, July 1st. Well, it's the 4th of July. I can drive. I'm not suspended. No, you can't. Because it's not very clear in the darn paperwork. We have to do something to reinstate our privilege to drive almost in every case. The exception will be if we pay off a ticket, oftentimes where a license will come back. But again, how do we check if our license is back? We go to the Department of Licensing website. We don't risk it. Because if you get charged with driving on a suspended license, if you get enough of them, you'll get a higher level of suspension. It turns into a big problem. So what's the long and short of it? The notices we get from Department of Licensing are a nightmare. What's the other part of it? The online stuff is really good and useful. So pay attention to the mail and then reach out when you need to Department of Licensing or attorneys to figure out what's going on, because when we make mistakes in these areas, it does have long-term consequences, and it really, really upsets us because we know how hard it is to read these things. So I hope you found that useful. I've been a little bit all over the place because, of course, that's the way I'm dealing with a mess. But if you find this useful, please like and please subscribe. More people see it, more people get the help they need. And more importantly, if you've got a criminal matter in Washington State, feel free to reach out to our firm. We've been doing this for many, many, many years. If we get on board, we'll listen to what happened, we'll identify a way forward, we'll be there for you. Thank you.